Hello everyone, I am Dr. Premchand from National Law University, Delhi. Welcomes to this lecture on the rule against perpetuity, a pivotal concept under the law of property in India. The rule, codified under Section 14 of the Transfer of Property Act 1882, aims to prevent the indefinite tying up of property and ensure its free transferability. By balancing the rights of property owners with the broader economic and social interests, this rule plays a crucial role in maintaining property, mobility, and economic growth. By the end of this lecture, you will understand the legal definition and scope of the rule against perpetuity under Section 14 of the Transfer of Property Act 1882, analyze the reasons behind the rule, including its historical evolution and public policy implications, examining key judicial interpretations such as Stanley versus Lay and the Duke of Norfolk's case, understand its application, explore exceptions to the rule and its interaction with related to sections like 13 and 20 of Transfer of Property Act. After attending this session, you should be able to describe the essential features and purpose of the rule against perpetuity, differentiate between permissible and impermissible transfers under the rule, apply the rule to practical legal scenarios involving property disposition, critically evaluate the rule's relevance and effectiveness in contemporary legal practice. Let us explore the topic in depth. From the times when human existence was restricted to hunting, gathering, and agricultural cultivation, the driving force behind evolution has been the promise of gains from privatizing common property, the desire to derive benefits from the exclusive right to use a property drove the evolution of social institutions like family. Property rights have now emerged as one of the key institutions of an economy. They shape the incentives for individual resource users are critical for economic growth and efficiency. The essential role played by property rights necessitated government interventions and regulation. In British India, the regulation of transfer of property was done through various scattered rules and statutes. In order to properly address the particular problems posed in the Indian context, a commission was appointed in England to prepare what became the Indian Transfer of Property Act 1882. With codification of the law relating to transfer of property, the government felt it necessary to ensure that property not become concentrated and keep changing hands to further economic progress. This necessitated the abolition of dispositions which make property inalienable for an indefinite period, known as perpetuities. Section 14 of the Transfer of Property Act 1882 espouses this rule against perpetuities and provides that where an interest is created for the benefit of an unborn person, it shall take effect only if the interest is to vest in such person after they attain the age of 18 years. Rule against perpetuity is accompanied by a number of rules and exceptions as to its application, raising concerns that the rule is too complicated in practice. This module aims to examine the application of the rule in India to assess whether beneficiaries and transferees are being deprived of their rights due to the complexity of the clause. Law has always strived to answer questions pertaining to how long does an owner have the right to tie up their property and how far one generation should be given freedom to dispose of property in ways that will restrict the freedom of the next. This has always involved striking a balance between complete freedom to tie up property in perpetuity on the one hand and the right to prescribe only the immediate devolution of the property on the other. Since medieval times, English law has had to deal with property owners who wish to tie up property indefinitely for the benefit of their family or any institution or cause, and the interest of society and the government that wealth should circulate freely and property shouldn't become inalienable. The policy of law has always tended to favor the free circulation of property and its alienation within reasonable limits, leading to the evolution of rules pertaining to the vesting of estates. The aim behind such rules is to ensure that there is no stagnation in the ownership of property, circulation of property takes place and isn't hampered. Since the end of the 17th century, a rule against perpetuity has been enforced in English law, restricting the future disposition of property by prescribing a time limit and holding those dispositions that fall outside the ambit of this as void. While the rule against perpetuity originated from English common law, it was also influenced by the statutory restrictions operating and dating back to the early 17th century. A significant flip to the legal framework was given by the Perpetuities and Accumulations Act 1964, which set a time limit or perpetuity period within which future dealings in the property must occur. The rule against perpetuities has two aspects. Firstly, the property must vest in the recipient within the period of lives in being at the time when the gift is made and 21 years thereafter. And secondly, the property must not be limited in such a way that makes it inalienable in the hands of the recipient. The rule against perpetuities was borrowed from English law and came to be incorporated in Indian law under section 14 of the Transfer of Property Act 1882, which states section 14 rule against perpetuity. No transfer of property can operate to create an interest which is to take effect after the lifetime of one or more persons living at the date of such transfer, and the minority of some person who shall be in existence at the expiration of that period, and to whom, if he attains full age, the interest created is to belong. After property in future estates came to be recognized and creation of future estates by way of shifting use and executory device began to be permitted. It was felt that property could be tied up in perpetuity by a single transfer unless a rule restricting the creation of such estates could be devised. The rule in English law has undergone many changes. They were first allowed to exist within the lifetime and were only later to continue for a reasonable time afterwards. Subsequently, the rule came to construe reasonable time as the period of minority of the infant actually entitled under the document of transfer. Finally, it has been settled that the time allowed after the duration of existing lives should be a term of 21 years independently of the minority of any person. Application of the rule against perpetuity. The rule against perpetuities was enacted in order to prevent the tying up of properties in perpetuity. This rule refers to two senses of perpetuity: inalienability of present interest and remoteness of vesting of future interest. Section 14 concerns the vesting of a future interest which may be delayed. In India, rule is applicable equally to movable and immovable property. This rule against perpetuities allows the creation of absolute interest in any property in favor of an unborn child, provided that a life interest is created in favor of any person living at the time of transfer. Section 14 moreover provides that no such transfer can operate beyond the lifetime of the life interest holder and the minority of the person in whose favor the transfer is made. This implies period of perpetuity, lifetime of life interest holder plus minority of unborn person, which says period of gestation if conceived at the time of the death of the life interest holder. Section 13 and 14 must be read with section 10 and 21 and cannot operate to complete exclude a right to alienate the property. In the case of Anand Rao Vinayak versus Administrator General of Bombay, a gift was declared void by the Bombay High Court as it conferred a life interest on the son, and thereafter the movable property was to be divided absolutely among the son and the son's son. Since an absolute interest was conferred on the life interest holder, the gift was voided under section 13 of TPA. In Abdul Fatah Muhammad Isaac versus Rasmaya Dhur Chaudhary of 1891, the Privy Council held that even under Islamic law, a gift to unborn generations is forbidden except in the case of publicly beneficial works. Exception to the rule against perpetuity. The rule against perpetuities is not applicable in the following cases. Transfer for public benefit. Any transfer made for the benefit of the public in perpetuity, that is for advancement of knowledge, religion, health, commerce or any other reason, will not be void. Covenant of redemption. Covenants of redemption in mortgage are not affected by the rule against perpetuity. Next is personal agreements. The rule only applies to transfers where there is a transfer of interest and does not affect agreements that do not create any interest in the property. Next one is preemption, where there is a clause in an agreement giving a party an option of purchasing the land. No interest is created in the property, so this rule does not apply. Next one is perpetual lease. The rule against perpetuity is not applicable to the contracts of perpetual renewal of leases. Other one is mortgages. The rule against perpetuities also does not apply to mortgages as there is no creation of future interest. Another one is vested interest. The rule also does not impact vested interest once they are vested, as it would adversely affect remoteness of interest. Other one can be considered corporations. Land purchased by or held by corporations is not subject to the rule. Another which can be considered gift to charities. There is a general common law exception to the rule against perpetuity with respect to gift to charities for religious, charitable and pious purposes. Another important aspect of exception is personal agreements. The rule against perpetuities is also not applicable to personal agreements. This was verified by the court in Ram Baran versus Ram Mohit of 1967. Difficulties in application of rule against perpetuity. The application of the rule in the Indian context has been fraught with difficulties. It has been argued that the rule is too complex in formulation and problematic in application, that it has led to families being deprived of property that was technically improperly vested. This, as discussed later, has formed a reason for the push of reform of the rule. The case of Sundararajan versus Natarajan of 1925 perfectly illustrates the anomaly resulting from the fact that a slight excess over the legally permissible limit may defeat the transfer. There was a question of the minority of ultimate beneficiary. An estate was bequeathed to the daughters of testator for their lives, with the remainder for the children on the attaining of 21 years. The Privy Council held that since it was not clear whether a guardian would be appointed for the minor in the future, for the purposes of section 14, the period of minority would be the normal period of 18 years. Since it is not necessary that a guardian be appointed for every child, there was a possibility that the bequest could be held beyond the lifetime of the daughters and the sons. The vesting could only be postponed to the life of the prior interest holder and 18 years. That is, the age of majority of the ultimate minor beneficiary, and the whole bequest in favor of the children was held to be void. In the case of Pultibai versus Sorabji of 1925, the testator devised his house upon trust to allow his daughter until her death or marriage, and all his sons and their respective families, including widows, to reside therein until the youngest of his grandsons should attain the age of 18 years. Thereafter, the property was to be sold and converted. The court held that during the son's life, their wives were entitled to stay as a result of the gift to the son, and not because of an independent gift. As all the sons were alive, there was no question as to the title to reside in the house that may be claimed by widow of the sons. There was a difficulty in ascertaining what could be the claim of a widow if she survived the son, since there was no clarity whether the whole interest of the testator was bequeathed. The entire transfer was held to be invalid. The application of the rule against perpetuities has thus created a number of difficulties, since it defeats the intentions of the testator while transferring their property. The need for reforming the law arose. What are the needs for reform in rule against perpetuity? Since 1930s, the rule against perpetuity has come under heavy fire in many parts of the world. Now, the rule aims to strike a reasonable balance between the desires of the members of the present generation and the succeeding generations to do what they wish with the property which they enjoy. It has become encrusted with barnacles and must be improved by simplification and strengthening. A deep dissatisfaction is felt with the rule due to two reasons. Firstly, the requirement of absolute certainty that the interest will vest within the perpetuity period, and its consequent invalidity if any possible combination of event, however improbable, cause it to vest outside the period. Secondly, the harsh consequences of violating the rule, whereby the entire interest in the property is deemed to fail rather than it merely being cut down to size. As a result, there is a general agreement that a statutory reform of the rule is necessary, apart from the fact that the rule causes injustice. There is also an ethical aspect to the need for reform. Usually, in the legal system, the person who violates the rule is the one who suffers. But under the rule of perpetuity, when the person violates the rule, property is taken away from the beneficiary and given to someone else. This also signifies a need for a cutting it down to size approach, where the entirety of property is not divested by only a reasonable portion of it. This can be seen in the case of Ram Nivas versus Nanku of 1926. A piece of land was transferred to the vendee, with the exception of 2 bighas of land which were to remain with the vendor and his lineal descendants, who would have no power to alienate the property. In case there were no lineal descendants, the property would revert to the vendees. The vendor dies issueless and the dispute arose between his reversioners and vendees. In the case, the court refused to look at the actual event that transpired. Instead, they considered that the possibility of events occurring, thus, even though the vendor had no issue, the court held that the clauses in the agreement created a life interest in favor of the vendor and his unborn children. This was held to violate section 13, under which only an absolute interest in a property can be created in favor of an unborn child, and would allow the property to remain for hundreds of years with the vendor and his family. The transfer was resultantly voided and the property was decreed to pass to the reversioners. Now, the proposals for reform. There are 3 main proposals on bringing about a reform in the modern rule against perpetuity. 1. Legislations specifically directed against well-known trade, which often causes a violation of the rule where the age limit is exceeded. Number 2, introduction of a wait and see rule, whereby the validity of interest depends on actual and not possible events. Number 3, general discretionary power to courts to reform limitations which would otherwise be void, so as to make them approximate most closely to the intention of the testator. In England, Professor Leach argued extensively for a wait and see rule. The law eventually came to be amended to account for actual and not possible events. However, not all amendments made in English law can be adopted in India verbatim. Attention must be confined to some important propositions which can deal with problems which arise with some frequency in India. This is, and 2 reforms have been recommended in the law. 1. That law have regard to actual and not possible event. 2. That mischief arising from conditions as to age should be remedied. To address any problems that may arise due to a technically faulty transfer that vests beyond the permitted period, it is important to simplify the formulation of law. At the list, it is recommended that the rule be applied leniently and harsh consequences such as the divestment of the entire property in question is not carried out. This would also respect the intention of the transferor in making the transfer. Thus, a significant reform is required in both the legislative formulation as well as the judicial application of rule against perpetuity in order to ensure justice. In conclusion, dear viewers, we can conclude that the rule against perpetuities was a rule adopted from English jurisprudence to ensure prosperity, industry and trade by ensuring that property does not stagnate in the hands of the few. The rule bars the creation of any interest that makes any property inalienable for an indefinite period by making any condition inoperable, where the property is to vest after the death of the interest holder and beyond the minority of the ultimate beneficiary. The rule deals with the tying up of property in perpetuity in two senses: the inalienability of present interest and the remoteness of vesting of future interest. Moreover, the different iterations of the rule have also undergone changes. The transfers were first allowed to exist within the lifetime and were only later to continue for a reasonable time afterwards. The term reasonable time was construed as a period of minority of the infant actually entitled under the document of transfer. Finally, it has been settled that the time allowed after the duration of existing lives should be a term of 18 years independently of the minority of any person. The rule, while simple in application, is tough to apply and has come under critique in countries all over the world. This module analyzed the application of law in India and found various instances where a mere technical error in the formulation of the terms of the transfer has rendered the entire transfer void. The requirement of absolute certainty that the interest will vest within the perpetuity period and its consequent invalidity if any possible combination of event, however improbable, cause it to vest outside the period, and the harsh consequences of violating the rule whereby the entire interest in the property is deemed to fail have created a deep dissatisfaction regarding the rule. As a result, there is growing push to reform the rule. The Law Commission of India too has reviewed a number of different formulations of the rule to address the deep inequity created by its application. Of all formulations recommended by the rule, there seems to be merit in the wait and see application of the rule, which requires the court to consider not only possible but actual event. Close to the rule followed by UK after the amendment brought about by Professor Leach, the rule seems idle since it does not require any actual legislative change, but can also be affected by a change in the application of the rule by the judiciary. Thus, the rule against perpetuity is a beneficial legislation which balances between the desire of the property owners to tie up their property for the benefit of their family or kinsmen and the need to avoid stagnation in the economy and ensure prosperity by free flow of property from one hand to another. It is, however, entrusted with Barclays and required some reforms in order to ensure effective operation. I hope this session has deepened your understanding of the rule and its significance in Indian property law. I look forward to engaging with you on more such thought provoking topics in the future. Thank you for joining me in exploring this essential topic on rule of perpetuity.